Mr. Williams, before you begin, first of all, we're grateful to Council for all the additional material. We've been thinking about the progress of this case, and through no fault of anybody's really, the Section 74 issue seems to us to be of very great significance. It's significant not only to this case and the way cases are conducted within the protocol, but it's also significant to even more broadly, from the way I look at things, to the development of the civil justice system and the way in which the online justice system, of which the protocol is a very essential part, works. Now, obviously, we haven't heard from Mr. Holland, and we haven't heard from Mr. Kirby, but and we want to. So we're not saying whether you're right or wrong, but the ramifications seem to me, and to us actually, to be more profound than had appeared before we started the case. Now, there are other issues in the case which may not directly arise if you were to be right, but of course we don't know if you are. And they are also quite important. And we are concerned that the time for argument left today, with everybody rushing to complete that argument, is not necessarily sufficient. And what we wanted to hear from you is this. Assuming that we need to hear argument not only as to the Section 74 issue, properly and fully exposed on both sides, all three sides, if you like, and assuming that we also need argument about what are the ramifications of your being right. In other words, assuming this is a non-contentious business agreement, and I'm very struck, for example, by the fact that in the Law Society's conditions it says this is a non-contentious business agreement.
It says it's not a contentious business. It doesn't say it's a non-contentious business agreement.
It's not a contentious, absolutely right. But same effect, I think, particularly in the light of the definitions. So we really need to know what the ramifications are for the costs regime. Now, we acknowledge that counsel in front of us are all hugely expert in the costs regime, but the bench is coming to this in some respects more from a higher level, let's say. And I don't think it would be right for the parties or for the court to reach a decision without being fully informed as to the ramifications of either side being correct. There's another further problem, and that is that if you're right, the whole process adopted here was nugatory, wrong, shouldn't have been. Now, it may be that another process would have been the same, but we will need to hear argument as to what the consequence of that is, and there has been no thought, as I understand it, addressed really to that question. And we need to consider whether the other questions in the case really arise, but they're very important questions themselves, and I, for one anyway, would want to address them if we could, because these cases, whether about £350 or actually £250 or nothing, don't come before this court very often. So this is an opportunity. And it's opportune because, as is well known, I am very, very keen to create a coherent civil justice system, of which the pre-action portal stage is incredibly important. Yes. And there is legislation, as I mentioned yesterday, going through Parliament, which acknowledges for the new Online Procedure Rules Committee the ability to govern the pre-action space. If it is a non-contentious space, so-called, then we need to understand the ramifications of that. And I've read all your extracts from Friston and the cost judges' views, and they all say that's all fine and it's what it is, but we need to hear a little argument about whether it's all fine or whether it's not all fine. So that's where we are. Can you tell me in turn how you think we should proceed? We're very willing to hear argument on Section 74 from all sides today, adjourn the other matters to another day, give you an opportunity to file further submissions when you've gone away and thought about all the things that I've mentioned. We're very willing to be told that a different approach is sensible, but what we don't want to do is to limit the argument so that we are in the dark, and then you find yourselves saying, I wish we'd had time to say this or that, and I wish we'd had time to think about this or that in the light of the importance of this issue, which yesterday, as you probably saw, Mr. Williams, the court hadn't quite got on top of.
I didn't perceive that at all, but I understand. Yes, I mean, certainly, I suspect it would be best we conferred. I didn't want to take up...
Well, I was about to say, would it be helpful if we...
Would it be helpful if you took some time? 15 minutes?
I wonder, unless my learned... I think my learned friends are nodding. So
I mean, do you have any... Okay, well, if you would prefer that as well, Mr. Kirby?
Yes, I mean, I was going to rise to my feet at the beginning today anyway, in the light of the late night, shall we say, documents that came over.
They were early morning for me.
Well, some came at 10 to midnight, and it's good bedtime reading. And I was going to suggest that it was a bit late to be dealing with that particular issue, namely the contentious, non-contentious divide. And it was going to be our submission that, in fact, the purposes of this appeal, this court didn't actually have to deal with that because this court is dealing with Section 74(3). And the notice of appeal dealt with the point as to whether there were the costs related to proceedings in the county court. So the notice of appeal referred to whether or not there were proceedings, not whether or not this was contentious or non-contentious business. We were also concerned, having seen, heard various points my own friend made yesterday and then seen the note today, that in fact, and as often happens when you think you have a new knockout point, query whether the full ramifications, as Lord Master of the Rolls has indicated, have been thought through.
Exactly.
Because we are, my learned friend was at great pains yesterday to remind the court that when it came to solicitor-owned client assessments, proportionality, strictly speaking, as a separate heading, wasn't a consideration. Well, if these are non-contentious costs, then proportionality comes back in because there are different rules with regard to the assessment of costs in relation to non-contentious costs. Apart from anything else, they have to be fair and reasonable. So they're not just reasonable, they've got to be fair. And one of the matters that the court has to have regard to is the amount of money involved. Now, that sounds, in the litigious sense, to be like proportionality. So we're not actually sure that my learned friends have actually thought through the consequences. Yeah. Oh, they have. Yeah.
Well, all of which is really by way of saying, would it be sensible if you had a short period of time to confer?
Yes. Or
are you saying, let's crack on and they've got it wrong and I'll correct it all in due course?
Well, obviously I would say that. I might be
slightly
longer, but my Lord, I don't feel that I'm in position to address, apart from anything else, I haven't read all the authorities, the 129 pages that were sent through this morning. I would not feel in a position to address you on the full ramifications of the distinction between contentious and non-contentious.
No, and I would want submissions on the consequences of Jet 2 here in this context, because I raised yesterday, and Mr. Williams, I think one of you Mr Holland maybe put in Jet 2. And Jet 2 is very significant because Jet 2 explains the status actually slightly better in a way than Lord Briggs, because what it explains is that the pre-action portal is intimately intertwined with the rules more closely than any of the other pre-action protocols or portals, and which we ascertained yesterday by looking at the rules, but it's true. And of course, it recommended the CPRC to consider the question. I'm not sure whether it ever did yet, but I wanted to talk to the Deputy Head of Civil Justice to ask him, because he would have known instantly, but I didn't get hold of him before coming into court. But I think we need to look at that,
Yes.
To see how that has been dealt with, because Jet 2 is a very significant case.
Yes.
And what I'm concerned about is having a really full vista. It's all very well having a very narrow question to decide, and the court says this is my answer to the very narrow question. That's normally my approach. I decide the issue and move on. But in this case, I don't want to do so, I don't want us to do so, without a very clear idea of the ramifications for the way this portal and its 690,000 cases a year works. Because if we did, we would be doing everybody a disservice. So if that means we have to adjourn, we will, even if you think it's better to adjourn this morning and leave it until another occasion. You would tell us how long you think you need it. So can you, with that sort of suggestion, talk about what you think is the best process?
Yes. Could I just ask a question about what you said a moment ago, Mr. Kirby? Because obviously we can all see that the argument has developed, and certainly, as you would appreciate, the bench has been assisted by the written submissions filed overnight. But ground 7 of the appeal, for which permission was given, is that the judge was wrong to find that Section 74(3) of the Solicitors Act 1974 applies to restrict the appellant's fees, as Section 74(3) only applies where proceedings have been issued.
Yes.
And the point there is that the submission is, and I don't think there's anything new about this, that that's what distinguishes contentious from non-contentious business. Now, it is entirely correct to say that that is an argument that's been developed yesterday afternoon and in the written submissions overnight. But is it your submission that the argument as to the distinction between contentious and non-contentious is not open to the appellant?
My primary submission would be that it is not open to the appellant, because the issue raised on ground 7 was the question of whether proceedings have been issued, whether it was necessary for proceedings to have been issued. The wording of Section 74(3) is obviously relating to proceedings in the county court, so it doesn't refer to the issue of proceedings. I accept that my own friend Mr Williams, in his skeleton argument, does refer to contentious and non-contentious.
And you didn't object to that?
I didn't object to that, no. That's quite right.
And anyway,
I speak for myself, I would be really troubled at being asked to decide the case on the basis that that point had not been put in the grounds of appeal, because we could proceed on an entirely false basis if that was there.
yeah, and furthermore, if on mature consideration Mr Williams came forward with a further application to amend his grounds of appeal, we would have to consider that in the light of all the things I've said about the importance of this litigation.
Yes.
I mean, we don't want to lose, and I hate to say this because it's precisely the opposite of what I normally say in cases. I don't want to lose the opportunity of deciding the case with fully cited. It would be very unhelpful to the future of this very important kind of litigation, which affects hundreds of thousands of people, and we would not be doing our job. So
Yes, I hope my response to my Lord
No,
Justice
you weren't.
Arnold wasn't indicating that I was urging you to press ahead.
I think we should do what my Lord
I
Chancellor
agree.
suggested. We should adjourn now.
Yeah.
Give you 20 minutes. Shall we resume at 11:15? Don't feel rushed. This I think 1.5 days turned out to be an underestimate for this case, and if that's the case, then we'll find more time for it, even if it's a little way ahead. It's not going to matter if it's a little time ahead. So you talk amongst yourselves and then come back and we'll resume.
Much obliged, my lord.
Thank you.
Compromise.
I mean, instructions, but speaking for myself, I think we should park the section 74(3) issue.
We got some.
Yeah, okay, I will. Yeah.
Otherwise, you're going to be.
Yeah, recorded, and no one wants that. Yeah, definitely.
We'll
We'll leave.
Well, I'm not on Twitter. I don't do social media. But I'm really interested in what you're saying about the Solicitors Act. Shall I try and put them up? Yeah, should we have a look?
All right then, yeah.
That's really kind of, we're forming a consensus, but we just can't speak for 5, if that's okay. We're forming a consensus outside.
Another 5 minutes.
So we can get another 5. Sorry not to come in soon. Thank you.
Can you just poke your head out the door when you're ready to go so we can just warm them up?
No worries. So as
Yeah.
soon as I come in, just
Yeah,
okay.
thanks so much.
Thanks.
Sorry, Dominic, that rather mucks up your...
No, it doesn't. It
It doesn't at all.
There's just more days ahead.
I
Right.
thought it was going to muck up your seminar.
No,
tomorrow.
no, no, no. I'm just going to talk about what has been. I mean, it's only a 20-minute little brief thing. Oh God, don't worry about that. Oh no, no. On the contrary, it's been. Do you think another 2 days?
Oh, that's true, isn't it?
What?
That's time.
It's time, 2, 3.
2 days. 2 days. Litigation never ceases to visit, particularly this court. People wonder, I guess what's happening up the road.
It's a fundamentally uncertain business. Something you've heard quite an lot over the last few months.
Right up there.
All the closure. Yes, thank you.
You can go back to your sister.
See you in Sunspell.
Sorry.
See you in Sunspell.
Open the midday.
Got nice readings on.
Filibuster 40 minutes.
Court rise.
Yes, Mr.
My lord, can I say, firstly, apologies again for my croaky voice. Secondly, the whole bar is tremendously grateful, if I may respectfully say so, for the extremely clear and structured way in which you express the conundrum. It's the feeling of all of us that we can't satisfactorily service what your lordship would be seeking in respect of the contentious and uncontentious business point today. Because, for example, and I hope your lordship will understand this, it is just in the nature of adversarial litigation that you focus extremely closely on the particular dispute before the court. And I think it's also right to say, and your lordship will know I don't say this in any sense at the expense of my learned friends, to the extent that some of the points that emerged yesterday, they're not really points that emerged between the parties, they're points that emerged from the bench. And so neither of us, for example, came to court to analyse whether there was any risk that there would be repercussions of my propositions hitting the sort of reforms which your Lordship has been discussing. And I think it's also right to say that all of us at the bar feel at present we're not very well informed about the nature of those reforms and the proposed legislation. And some of the case law, for example, your Lordship has referred to, like Jet 2, we all know the case, but I certainly haven't read it in the last
I think it's not the reforms in a sense, because the draft legislation is always the last thing we need to look at. It's just though to be aware of the importance of the pre-action portals. So what we don't want to do is to put 600,000 putative claimants and 600,000 putative defendants in a more difficult position than they are already. If we don't have to.
Of course,
the law's the law.
But what I think is right to say is that if I can make a sort of weak Shakespearean allusion, none of us, I think, quite anticipate the sort of do but untune that string and how what this court follows are sort of points that were coming from your Lordship about those proposals and indeed about the system which now exists. So I think because of that, it's a consensus from all of us that we can't satisfactorily meet your Lordship's needs in respect of Section 74.3 today. What we've, and contentious and uncontentious business dichotomies and such like. Well, the consensus at the bar, Mr Holland is neutral, and I think Mr Kirby and I, our preference, though we're in your Lordship's hands, is if the matter is to go off anyway and the judgment is to be delayed anyway, that everything go off rather than we attempt to salvage something of today.
Can I tell you why I think that may be right?
Yes.
The fiduciary duty argument, if we were thinking it through together whilst having a very welcome cup of coffee, Mr. Williams, you perhaps didn't get one. But the point is this, that if it's non-contentious business, and if Section 74 didn't apply, and if the assessment was conducted on the wrong basis by the district judge, then the question of the right basis of assessment, namely fair and reasonable, could, or maybe could not, be affected by the question of fiduciary duties.
Yes.
It would therefore be unwise to proceed with the fiduciary duty argument on the false basis that you were wrong about the Section 74 argument without thinking through the possibility that you're right.
Yes.
I mean, I'm not prejudging any of
course.
these questions, but so we would want to hear argument. Now, what I was going to propose, and it sounds as if it's similar to what you were going to propose, is that we should go away and put this down to experience, adjourn for a new hearing with directions for everybody to exchange or file new skeleton arguments dealing with everything that is now in issue. You all have to tell me whether you think you need to amend your notice of appeal, but we provisionally don't think you do.
No. That was going to be my position.
Yes, we don't think you do. We think the matter's sufficiently raised, but we'll hear Mr Kirby on that. And then adjourn for as short a time as possible for a new hearing to start from scratch, effectively, with all the arguments bottomed out in writing. And we would ask you to scrap the multiple skeletons we now have and to all file a comprehensive skeleton.
Indeed, yes. Yes. Well, I think if remember a long time ago, Lord Justice Taki saying the danger of knocking at an open door is you fall through it. So I simply I would say no more than that. I think my learned friend Mr Holland may have had some issue as to whether there should be a facility for the law, for the parties to put in any evidence. So I don't know if he wants to address you on that.
I don't want to press it. I welcome the opportunity of going back and seeking the views of the society on the impact, because it's something which, in a general basis, we might have some helpful input, hopefully, as of the general ramifications of any judgment that this court might give on the dichotomy in this between non-contentious.
But if you felt if you felt, particularly you, Mr. Holland, but also the other parties, if you felt it would be useful to the court to have evidence on what common practice is in any area, that you may come to you when you're actually considering the points that I've raised, then I would urge you to put that evidence forward, seek consent for its submission from the other parties, obviously make it as non-contentious
Yes.
as possible. I can't see any particular reason why it would be opposed, and it might be useful. On the other hand, there may be nothing.
My lord, I just flag it up. I'm not making any application now.
No.
But certainly, it's happened before. I've intervened on behalf of the Law Society in this court where we have put in evidence on it was one of the CFA cases many years ago.
Can I say one more thing, which is that provisionally the court would be at the moment inclined, not whatever decision it reaches, to send this case back to the district judge, but rather to, if it can fairly do so, to reassess the costs on the correct basis, if that is the outcome, rather than sending you all back to start again and have another round of appeals.
Yes.
So we would much prefer to make this the very last hearing in this
Yes.
case if we possibly can. That's only a preference. It may not be possible. You may say it's unlawful or inappropriate or ultra vires. I saw that in your submissions.
In a very different context. But
My lord, the only other thing I flag is this. It has been known for this court to sit with an assessor.
Yes, I was thinking of that last week.
Certainly in the CFA cases, I think Hollands and Cannery, it was Chief Master Harris sat.
Yes, well, I was actually thinking of that at the weekend, and I thought it was too late. Leave that to us. We'll decide if we might get the chief
I mean,
cost
that would at
master.
least give you some knowledge, background knowledge as to it may be that in that case the Law Society would need to put in evidence because any assessor who was a cost judge would.
No, I think we would try and get Judge Gordon Saker if we could. Yeah.
My lord, in that case, I certainly don't propose any.
Good. Now, Mr. Kirby, poor old Mr. Kirby's been left very much.
Well,
third
it
in
may be
line.
poor Mr. Kirby actually, because obviously one of the matters obviously that do have concern about is obviously the very considerable additional costs that are going to be involved in all this.
Yes.
But can I park that just for a moment? My lord, so far as all the other suggestions are concerned, we are content with those. I obviously take on board my lord's comments with regard to the notice of appeal, and I don't intend to push that any further. My lord, one point that we discussed outside was whether in fact there should be a list of issues. And I appreciate that that's what notices of appeal are supposed to be about and what respondents' notices are supposed to identify. But we did wonder whether it, in fact I think we agreed, that a list of issues would be helpful, and it might indeed be helpful if they were not only agreed between the members of the bar here, but also if they were submitted to the court.
Yes.
For the
I mean,
court.
I identified 5 issues from the grounds of appeal and the respondents' notices, which were broadly, did section 74.3 apply to claims brought through the RTA portal without county court proceedings actually being issued. That was before we got into non-contentious business, but I think it's the essential point. Did the solicitors owe the client fiduciary duties before the retainer was agreed? Did those fiduciary duties mean that the exemption from section 74 contained in part 46.9.2 only applied if the client gave her fully conformed consent to paying excess costs? If no such fiduciary duties were owed and section 74 was disapplied, was the term in the solicitor's retainer requiring the client to pay excess costs unfair? And did the client give her fully informed consent to the term requiring her to pay the excess costs? Now, those were the issues. I think they may have to be reformulated or added to look at the ramifications.
I think refined, certainly the first issue.
The first issue perhaps needs separated out. But I would encourage the parties. I mean, have you thought about timing?
Well, in terms of the length of any adjourned appeal, we think that probably it's going to require 2 days.
Yes, I think 2 days.
Yeah.
And
I think I'm going to allow 2 days with a third day available.
Yes.
Because I don't want to be rushed.
We haven't talked timetable in terms of submissions, and I hope it won't be too immediate. But obviously we need to get on with it. But
is there any pressing urgency from any party's point of view?
Not for our part.
can I just
There are these other
Forgive me,
cases,
Mark.
aren't there? There are other cases. Are the other cases stayed?
Yes. Are the other cases stayed?
Yes, there are about 900 cases stayed pending.
They're all stayed, are they?
They weren't
Right.
mentioned when this was said to be a test case yesterday. I'm just pulling Mr. Williams' leg.
I didn't know. I don't think they're our cases. I think they're their cases.
Yeah, well, I hope they're not your cases. Otherwise,
Grounds of appeal say it's a test case, so that
yes.
I assume there are other cases.
I mean, that to some extent makes it pressing, but obviously they're stayed. So
Well, I mean, I would want to get on with this. What I would be inclined to do is to, let's just try and map out something. Let's say we allowed 2 weeks for the parties to agree a list of issues and submit them to the court. If not agreed, you'll submit them to me and I'll determine. But I would urge you to agree, even if you say, well, this is not, one person says, well, this is not really a essential issue, but just put it in. But make it as crisp as you can. I don't want 500 issues. And then submit revised skeleton arguments. Now, is it sequential? Is that more useful? So, you know, Mr. Williams and Mr. Kirby, Mr. Williams and Mr. Holland followed by Mr. Kirby, or what?
but I think bear in mind the significance now of the contentious, non-contentious issue. I think sequential exchange perhaps would be of assistance.
Do you think?
Yes, I think so.
Yeah, I think so. Okay, so
My own point is, I'm neutral in a way that we will put in our submissions and have an attitude one way or the other, but it might assist if the society knew what position the parties were taking.
yeah, so you'd want to be coming afterwards, really.
Ideally, but I'm conscious that you know we're not a party, we're not a party
No.
with skin in the game directly here. But
No.
yes, we would want to know. We could
Well, I
put in
think-
submissions on a general level.
14 and 21. 7 days, 14 days and 21 days after the list of issues.
Just say it out loud.
Well, I was going to say 7 days for Mr. Williams after the list of issues, so 21 days from today, then 28 days from today,
Oh, I see.
and then 35 days for the Law Society.
Yes, we'd be quite content for the Law Society to follow on from us
Which,
because
if my maths is right, would take us until the 30th of March.
So we could fix it for next term if we possibly can.
Yes, forgive me. I was talking to Mr. MacDonald, but the one that, if obviously not just chatting, one point that slightly concerns us about sequential is as I say, because some of the points that were raised yesterday came from your lordships. What I've called the do but untune that string point, for example. I'm not sure the extent to which Mr. Kirby will be taking these points, but as long as that is made clear to us, whether he is taking points like that when we are negotiating
come out
the
of
list
the
of
list of
issues.
issues.
Exactly.
Yeah.
That was just. So I was really saying this as much to Mr. Kirby, but then we're entirely content with what's proposed. The other reason I was talking to Mr. MacDonald was just to make sure about his availability during the next 3 weeks, if that is to be the timescale. I suppose that I haven't thought about how it flushes with the terms, but if it was possible for us to have 14 days after the list of issues instead of 7?
That would
That would
still
be
be
our
within this term.
Yes, I think that
preference.
would still be okay.
Yes, I was going to say, I wouldn't want that to derail matters, but if it doesn't derail matters, then
So if
that would be
if
my
the list of
request.
issues is 14 days from today, your skeleton 28, Mr Kirby's 35 and the Law Society's 42, that
Yes, and can
takes
we,
to the 7th of April.
can you
6th of
reflect that in an agreed order that
Yes,
the
of course.
juniors could please submit to the court? The other thing that I was thinking is that this is a case where the court would find it, speaking for myself here, would find it very helpful to have a transcript of
Yes.
what passed yesterday and today. One has complete recall now, but in 3 months' time,
2 months' time.
I can tell you with no fear of
The
hesitation.
tabula rasa.
Yes, the only, I apologise in advance to the transcriber for having to try to hear my voice in its current state. But Mr MacDonald reminds me of a highly technical issue, but given the potential breadth of the arguments, can we ask your lordships to excuse us from the 25-page limit for the skeletons?
We can excuse
Within
you
reason.
from the 25-page limit, but we will require concision.
Yes, well, I have to say I do aspire to it.
Yes.
Hard to believe as it may be.
Yeah, and we would also appreciate if the authorities that are referred to are carefully selected and not just scattergunned.
Yes, and also when your lordship was sort of talking about consolidating the skeletons, I assume that one of the I have to say things that I found slightly annoying about the appeal bundles is they had lots of ancient skeletons in. But I assume that your lordships are happy that they can just stay in there rather than we need to redo the appeal bundle.
No, you don't need to redo any
I'm
bundles,
obliged.
save the authorities bundle, which I suggest you do redo
Yes,
with everything in when the
that we
skeletons
actually
are
need.
all together.
Yes.
And we will, so okay, so with all that, we will adjourn this on those terms, and perhaps the parties can attend the listing office as quickly as possible to refix. Obviously, we would like to have the same counsel, but if one or junior, for example, can't make it, well, you might have to be reasonable about that.
Understood.
I think we should direct that it should be heard by the 31st of July, if at all possible,
And before the same court.
and before the same court, which obviously is going to be a limiting feature.
Yes, sorry, was that the same constitution? I didn't quite
Same
hear.
constitution.
I thought so. Thank you, my lord.
So you can put that in your agreed order.
My lord, I realise that what I'm about to say is little more than putting a flag in the ground. But, my lord, obviously we are concerned in relation to the costs. This all arises out of a point that was not raised before on the first appeal. And we're now in the middle of very substantial work and a very lengthy hearing. And there are going to be very significant costs as a result.
Well, that's something that will need to be visited at the end of the hearing.
I appreciate it, my
We
lord.
fully understand that. I think I speak for
I mean,
all.
there is, we fully understand that. There is obviously I don't know whether it applies here, but there are cases where protective cost orders can be made. I would certainly urge the parties to consider the costs and where they're going to fall, so that there isn't an unreasonable distribution of costs. But if they don't, and no applications are made, we will, as my lord said, have to deal with it afterwards.
Yes.
But we're likely to be relatively sympathetic to the fact that this has been useful litigation, not unnecessary litigation.
I'm grateful.
Yes, well, I don't think I should say anything at this stage.
No, I think you shouldn't.
Okay. So cost reserved, I assume.
This will be, obviously, we don't make
Yes.
interim cost orders in the
Yeah.
Court of Appeal. It's we deal with the appeal at the end.
Infradig, yes.
So if you submit your draft order, and many thanks to all for interesting discussion, which we look forward to resuming in the summer.
Thank you, my lord. Good morning.